I'm Jesse Reyes, and I'm on the Illinois Appellate Court, 1st District, 5th Division. The Appellate Court is different because we review what the trial court has conducted. So we review the record, we review the briefs that's supplied by the parties. So we don't actually see the litigants per se. I guess one of the key distinctions between the trial court and the appellate court is that the witnesses have already testified, and the trial judge determines based on the testimony, the credibility of the witnesses. We view that in terms of black and white, in terms on the paper. And so, we in many cases will defer to the trial court in terms of the credibility of the witnesses. The trial judge observed the witness testifying on the stand, had a better perspective of whether the person was believable or not, or credible. So we will defer in many cases in those type of situations. So that's one of the key distinctions between the appellate court and the trial court. Also, at the appellate court, we're kind of devoid of emotion. Sometimes in a trial court, there'll be emotion, especially in emotional cases. So the jury or the judge may see a lot of emotion. And in our case, when we look at a record, it is sort of devoid of emotion, from the fact that all we're looking at is just the arguments made by the lawyers and the issues that they raise for the appellate court to consider. And one of the things that I guess the public should be aware of is that we look at the issues that the trial court or the trial lawyers have indicated they feel are issues that we should look at in terms of the errors that maybe they were committed either by the trial court, by the trial judge, or by one of the parties in the case. Well, we review the facts also, because sometimes the facts may be skewed one way or another, and the parties are asking us to also look at the facts. So we do look at the facts as well, and particularly in terms of trying to understand what happened at the trial level, what did the trial court consider and not consider. For example, if there's witnesses that are excluded from testifying, why were these witnesses excluded? How did they impact the trial or the proceeding? So we do look at the facts. The facts are very important for us to understand what happened at the trial level. But also sometimes if there's an issue with regards to the facts, the parties will bring that to our attention, indicating this occurred and the trial judge didn't consider this, and the trial judge should have considered these particular type of facts. So we do look at the facts. We do look at the law that was applicable at the time in terms of objections or things that were not allowed to go into evidence. And that is what the litigants will tell us the issues are. Well, if we don't agree with the finding of the lower court, we'll either reverse the lower court, or we might reverse it and remand it, meaning that we may not totally disagree with the entire proceeding, and then we'll remand the case with instructions, or sometimes we'll remand it for a further hearing. Let's say, for example, maybe there should have been an evidentiary hearing during the proceedings, and an evidentiary hearing wasn't conducted. So at that point in time, then we'll reverse the case and remand it and ask the trial court to conduct an evidentiary hearing. Right. Unlike the Supreme Court, the Illinois Supreme Court and the U.S. Supreme Court, the appellate court, when a case is appealed, the appellate court has to review it and then make a determination whether or not there's appealable issues or not. Sometimes the issues that we are asked to consider are not appealable issues, or the case isn't ripe for appeal, and then we'll deny the appeal. But every case that is appealed, we have to consider. I'll describe what a day is like for oral arguments. We conduct oral arguments, and every division in the 1st District has a day that they're assigned to have oral arguments, and ours is on Tuesday. And so what I'll do is early in the morning I'll come in and go over my notes, having prepared for oral argument. I view preparing for oral argument as sort of like preparing for final examination. So I look at my notes, I look at the briefs that the parties had submitted, the case law that is pertinent to the case, and then in many cases in our division we prepare what's known as a bench memo. So if I'm the author of the case, I'll look over my bench memo and just kind of refamiliarize myself with everything, and then proceed to go down to the robing room in the courtroom. And then at that point in time, my colleagues and I will go on the bench. Now, one thing I should point out is that we sit in divisions of 4, but we sit on a panel of 3. So when we hear a case, there's 3 of us that are sitting on the bench. But they have us assigned, the Supreme Court has us assigned as 4 justices per division. So one of us will always be rotating in and out on a case. So that gives everybody an opportunity. So once we get on the bench, then our clerk calls the case, and as presiding judge of our division, I'll ask the parties to step forward, to identify themselves, and then basically just to give them a few of the ground rules that we have in our division. One of them is that each side has 15 minutes to address the court. The appellant, the party bringing the appeal, has an opportunity to do a rebuttal, and we ask them to save some time for rebuttal. After that, then we ask them to sit down, and then we proceed with oral arguments. And we tend to ask a lot of questions, and so the parties should be prepared to respond to the questions that the court puts forth. Then after both sides have had an opportunity to address the court, we'll recess, and then we'll go into conference and discuss the case and the issues, and whoever the author is will indicate why the author is going the way the author thinks the case should go, and then the other 2 will discuss their views and based on what happens in the oral argument as well.